Okay, good morning, everyone. My name is Jeremy Herman, as you see on the screen. I am an employment lawyer at Samfiru, Tumarkin, LLP. I'm located in Toronto. Um, as you might know, for those of us who watch us frequently, and for those of us who are new, we have offices in Toronto and Ottawa, and also in Vancouver and Calgary. And our goal is to do as many of these Q&A sessions as possible to ensure that your questions are answered. And so we do them in Toronto, we do them across all of our offices every week. And again, the goal is to educate the public, make sure that you have an opportunity for free to get your questions answered live. So please utilize this opportunity that you have now. Any questions you might have, just send them into the chat and I'll make sure that I answer them to the best of my ability within the time that we have. And as I normally do, I'm going to start off with an important topic, and then we'll get into some of the questions. So right now, and I've spoken about this before, but it continues to be a trending issue. And so it's important to talk about it again. And that is the idea of working from home and hybrid work arrangements. And so, as we all know, during COVID, most of us went to work remotely. Some industries did not. They couldn't do so. Of course, healthcare is one of those examples. But many industries did go remote, and their employees could be, for the first time ever, started working remotely. And that came along with some challenges, but also a lot of flexibility that employees may not have had before. I know personally I was able to work remotely, and it was great to be able to manage that with my childcare obligations. I was able to throw up a load of laundry in the middle of emails or in between emails. And so that flexibility is beneficial. It cuts down commuting time, and there's a lot of research about how it's beneficial to work remotely in many ways. But now what's happening is we're seeing a trend of employers requiring that employees return to the office. And some employers are requiring that they return to the office full time. Some employers are implementing hybrid policies where they have to return part time. It could be 1 day a week, 2, 3 days a week. And we see a lot of diversity in these policies. Some employers are saying it's got to be 3 times a week and you got to come in Monday, Wednesday, Friday. Some employers are saying 3 times a week, but you get to choose which days you come into the office. So there's a lot of different policies that are out there. Some employers are very closely monitoring their employees in terms of when they come into the office, and some are not. And in fact, today I just spoke with a person about an hour ago, and she was explaining to me that she is required to now go back to the office. She hasn't worked in the office for 3 years. The problem is she bought a new house that's farther away, having expected that she will work remotely from here on out. And she, of course, like many of us, has childcare obligations that are going to be difficult to manage. So these are policies that we're dealing with now in this post-COVID world. And so the question is, what rights do you have in this situation? Do you have a right to continue working remotely? If your employer is requiring that you come back, can you assert that you will not come back? And you're entitled to severance pay because you're not going back to the office and your employer can't force you to do that. So the answer in a nutshell, and I say in a nutshell because each case is different, but in a nutshell, the answer is this. If you worked remotely prior to COVID, whereby COVID was not a unique situation for you, you always worked remotely, or you did for a little while before COVID, so working remotely during COVID was not new for you, then if your employer is now requiring that you come back to the office, you can argue that that is a change to the terms of your employment, being required to go back into the office, even if it's only part-time. And you can argue that that is a constructive dismissal of your employment, which means, as we've talked about before, constructive dismissal means your employer is unilaterally changing the terms of your employment in a way that you don't agree. You don't agree to those changes. And so you can assert that I'm not accepting the changes, and you're forcing me to resign, employer, and therefore I'm owed my full severance pay as if you terminated me. That's called a constructive dismissal. And we'll talk more about that, I imagine, today later in the session. On the other hand, what could happen is that COVID was a unique situation for you. You worked remotely only during COVID, in which case now your employer is asking you to come back. They have the right to do that. And typically you'd have to go back. Of course, your employer can't force you to literally come back. You're not a slave. But what they can do is say, you got to come back. And if you don't, it's considered a resignation of your employment. And that might be true in that situation, where you only worked remotely during COVID, you never did before, and now you're being asked to come back again. Why? Because COVID was a unique set of circumstances. And while that might be difficult to manage going back to work, in that situation, your employer probably can mandate that you do come back to work, either full-time or part-time. But again, each case is different, so please don't hesitate to contact us and to learn more about this. We're happy to answer your questions and see what we can do for you. Okay, so starting off with that, let's now jump into questions. I'm happy I see a few in the chat now. So I'm going to start with Saeed on Facebook, who says, I started a new position at my company after transferring from another department. This new position does not have a lot of tools available for training, and I keep getting negative critique. I'm worried this will lead to losing my job. What are my options here? Great question, Saeed, because this is a very common situation. So you're at the same company, not a new one, but it's a different department, as you said, and so you require some training for how to go about your work in that new job. And so you have to put everything in writing. First of all, you need to put a request in writing. You have to say, I need further training in writing, right? And your employer should respond in writing. And if they don't, make sure you send a follow-up in writing. Again, I'm emphasizing this in writing piece because what could happen is if you have a conversation orally with your employer about how they have to provide further training for you, and if they don't, and you end up losing your job as a result, which you suspect might happen, your employer can say, well, you never asked that you have further training because it wasn't in writing. And so you got to make sure all this kind of correspondence with your employer happens again in written correspondence, and that you save that written correspondence just in case you might need it. And that very well might be the case that you will need it. And so you could end up losing your job. It's possible. In this case, if your employer says that your performance is very poor ever since you started in that new department, your employer take the position that you're not owed severance pay. They could say, we're terminating you with cause, which means without severance pay. In that case, you likely still are entitled to severance pay because your employer will not be able to establish that they can withhold your severance pay just because your performance wasn't up to par, especially if they didn't provide the training that was necessary, and especially if you asked for it and don't get it. So make sure that you ask for it, and then you can document that, and you can show, well, I asked for further training. I wanted to improve my performance. I wanted to make sure I do a good job in this new position. And so that's very important. At this point, I think it would be important to talk about severance in general and how it's calculated. Because, Saeed, what could happen, whether you're terminated with or without cause, is that you'd be entitled to severance pay. Okay, if you're terminated with cause and you can fight that, and you're entitled to severance pay, just as if you would be terminated without cause, which means with severance pay. So either way, what does your severance look like? And the answer to that is severance is calculated based on certain factors. And those factors are your age, your length of service, what position you were in, how much money you were earning, and generally the availability of similar positions in the job market right now. And so that is how severance is calculated. And what you can do is use our tool that you see on the screen right now. It's called the Pocket Employment Lawyer. Within that Pocket Employment Lawyer, there's something called a severance pay calculator. And what that does is it asks you very simple questions. It's anonymous and free, and you answer those simple questions. I believe there's 4 of them, and then our severance pay calculator will spit out an amount of severance that you are likely owed if you're terminated. And this is a very, very helpful tool. Lawyers use it, the public uses it. It's free and anonymous, as I said, and it will give you an idea of what kind of severance you might be owed in your situation, because again, it is very context dependent. So take a look at that tool. Again, Pocket Employment Lawyer, and you could find it at pocketemploymentlawyer.ca. So Saeed, I hope that answers your question. If you have a follow-up, please post it in the chat and I'll make sure that I get to it. Okay, now we're going to move on to Chantel. So Chantel says, if someone felt they need to resign, sorry about that, I'm just going to plug in my computer here. If someone felt they needed to resign because accommodations for their special needs child were removed, are they entitled to constructive dismissal after the fact? Okay, so Chantel, I think I understand your question. It seems like you're asking if you had to resign because maybe a school program did not accommodate your special needs child, are you entitled to severance pay, and can you claim constructive dismissal? So it's a good question. The answer is likely not, because it depends who the accommodations are from. If you're asking whether your employer has to accommodate you, the answer to that is yes. In most cases, they do have to accommodate you. Otherwise, it's a breach of our human rights laws. But if it's another party, not your employer, who failed to accommodate the needs of your child, you can't claim constructive dismissal from your employer. It has to be that your employer failed to accommodate. So it depends on what you're talking about, Chantel. But again, it's a good opportunity to talk about constructive dismissal. So I mentioned it earlier. What that means is that your employer is not terminating you outright. They're not saying, Chantel, we're dismissing you. Instead, what they're saying is, I'm changing the terms of your employment. I am either changing your pay, I'm changing your work location, your work hours, your duties. I am, you're in an environment where you feel like you're being harassed or mistreated. That could also be a constructive dismissal of your employment. And so in that case, you can resign, you have to claim constructive dismissal, and you'd be entitled to your normal severance pay, which I talked about earlier, how that might be calculated. So Chantel, I hope that answers your question. If you have a follow-up, post it in the chat, perhaps provide some more clarity as to who is the accommodation provider. Is it your child's school? Is it your employer? And then I can answer that question in more detail. Okay, so we're going to move on here to, okay, Chantel wrote a follow-up. So before I move on, she said, employer removed accommodations for employee to work from home when issues arise at school. So I'd have to take a look at that situation more closely, Chantel. Perhaps set up a meeting with us and we can speak about this. It sounds like if you had accommodations and your employer stripped that away from you, you could argue constructive dismissal. You could also argue that it's a breach of the Human Rights Code if you're in Ontario. So let's talk further about that. Contact us at employmentlawyer.ca or email us at help@employmentlawyer.ca. And we can figure out what the accommodations were and how those were removed and how that impacts you. Okay, so let's go on to the next questions. So Vera on YouTube says, I've been off of work for almost 6 months due to a medical condition. I'm clear to return to work now with some restrictions, but my boss says previous position no longer exists. Do I have to accept a new role at a lower rate of pay? Absolutely not. Your employer has to, not only do they have to accommodate you within your restrictions, as long as those restrictions are medically documented, your employer has to accommodate you. If they don't have a position for you, that's comparable and that's within your restrictions, then one that could be a human rights issue, absolutely. And you can also argue that that is a termination of your employment, because your employer, if you've been off on a leave, then your employer has to provide you with the same position when you come back, or one that's very comparable. And in this case, also one that's within your restrictions, Vera. So I hope that answers your question. You do not have to accept a new role that is at a lower rate of pay. Again, that could be a constructive dismissal because it's a term of your employment that has changed, meaning your rate of pay. But again, contact us at employmentlawyer.ca. Let us set up a consultation with you and figure out what kind of restrictions you have, what the medical documentation says, and then we can talk further about that and what your options are in terms of getting severance and leaving your position if that's necessary. Okay, so let's move on to a question from Rebel. So Rebel says on YouTube, when does overtime kick in for local truck drivers in the city of Toronto? So Rebel, I can't answer that question because it depends on a few situations. First of all, the main thing is it depends on whether you work for a company that is federally or provincially regulated. Some trucking companies are federally regulated, some are provincially regulated, and the answer with respect to overtime depends on that. Each legislation in the federal context and in the provincial context says something different about overtime, and so we have to look at that. So again, contact us and we can set up a consultation. You'll inform us of all the information that we need to know. You'll send us all the documentation. You'll send us pay stubs indicating what your overtime is, and then we can answer your question about whether you're entitled to overtime and overtime pay, that is, and if you're not receiving it, what we can do to help you to get it. So Tanya, now moving on to Tanya on YouTube. Tanya says, how do you claim constructive dismissal if problems keep getting worse? So Tanya, this is an important question because you need to claim constructive dismissal fairly quickly. If you allow issues to fester and to become more problematic and you haven't said anything to your employer until then, your employer might be able to defend the argument that you have for constructive dismissal by saying, well, you didn't say anything. You got to let me know if there are issues. So let's say, you're dealing with a boss who is harassing you. Okay. And I speak to people in that situation all the time. I always say to them, you need to make this known. You need to, in writing, document this and send it to whoever it might be, a manager, a supervisor, the head of the company. It depends on your situation. HR, certainly, if there's an HR department. You got to make the issues known. Otherwise, your employer will say, well, we didn't know about it. We couldn't do anything about it. And so you can't really claim constructive dismissal. So very important when these issues are arising, you might want to, first of all, set up a consultation with us so we can explain to you how to go about this, what to put in writing. So contact us at help@employmentlawyer.ca and we can walk you through that, Tanya. We can let you know what kind of things you have to put in your correspondence to your employer and how to claim constructive dismissal, because it's very important that you do it properly and that you do it at the right time. So I hope that helps answer your question. And so at this point, I'm caught up. I'm going to answer. Oh no, we have one from Bobby Dillon. Okay, so Bobby Dillon on YouTube says, what government bodies are there for people that have been falsely accused and fired because of that false allegation, which also got the employee denied for EI? So what it sounds like in this situation is that you were terminated for cause. And I touched on this earlier. termination for cause means your employer says your conduct was very, very poor. You engaged in severe misconduct, and therefore you're not entitled to your severance pay when we terminate you, which you're normally entitled to. That's called a termination for cause. The issue is that employers do that all the time when there is no cause. So employers will say, your conduct was so terrible and therefore you're not getting severance. But the issue is that your conduct was not so terrible to the extent that you should not be receiving your severance. And again, that happens all the time. So if you're terminated for cause, you often are still entitled to your severance. Not always. Sometimes your employer does have cause to terminate you legally, but in many cases they don't. And you're absolutely right, Bobby, that in that situation, it is very common to be denied your employment insurance benefits. So that's another issue with being terminated for cause. And again, these are all things that we can help you fight. If you're terminated for cause, if you were denied EI, you can absolutely contact us, set up a consultation. We can go over the reasons for termination because, again, very context dependent. It depends on what happened. It depends on what the misconduct is that your employer is alleging. And we can, again, walk you through that and help you determine whether you are entitled to severance and how much that would be. And we'll help you in that situation, Bobby. And in terms of government bodies, well, you can go to the Ministry of Labor, but I recommend that you deal with this through a law firm, and you can contact our law firm. Obviously, you want to contact an employment law firm with this issue, because it could be that you're entitled to your full severance pay, and the Ministry of Labor will not be able to help you get that. It cannot help you get your full severance pay. That you need the help of a lawyer to do. So please don't hesitate to contact us. You can reach us at help@employmentlawyer.ca. Okay, so jumping back to Tanya. Tanya says, could you explain what steps are next if the labor board accepts your claim? So Tanya, again, you often don't claim constructive dismissal through a labor board. In this case, in Ontario, it would be the Ministry of Labor. You actually do it through a lawsuit, okay? And that is different from the labor board. And so it's important to understand these differences. And so that's what I'm here to help you understand today. If you have issues with your employer, whereby you think that you're being constructively dismissed or terminated, you have to contact us so we can help you with what those next steps are. Usually the next steps are telling your employer that I have been constructively dismissed. That is my position. You explain why, and then you move along with trying to negotiate your severance. And if that fails, then you might have to sue your employer, and we help you throughout that entire process. So please contact us, Tanya. Again, this is not something that typically is done through the labor board, and those aren't the steps that we help you with as a law firm. So contact us at help@employmentlawyer.ca. Okay. So Rebel says my company. So Rebel had asked earlier about trucking and overtime and the trucking industry. So Rebel says that he thinks that the company is provincially regulated. So if it is provincially regulated, then typically overtime is after 44 hours of work per week. Then you're entitled to overtime, which is very, very common in the trucking industry. But again, it depends really on whether it is federally or provincially regulated. Sometimes it isn't determined on which lines you cross, Rebel. You said that you don't cross provincial lines. It still may depend. So contact us and we can do a further assessment of whether your employer really is federally or provincially regulated. But generally speaking, according to Ontario, 44 hours of work is a full work week. Okay, and beyond that, you would be entitled to overtime pay. Okay, and Tanya, I'm happy to see this back and forth. So Tanya gives another follow-up. She says, does the information apply for government workers? yes, the information would apply for that as well. So if you're working for the government or another federally regulated employer, you can still claim constructive dismissal, and we can still help you with that situation. If you're non-unionized, if you're in a unionized setting, then we may not be able to help you, and we likely won't. But if you're not unionized, even if you work in a government position, then we can certainly help you if you think that you're being constructively dismissed. So don't hesitate to contact us in that regard. Now, at this point, I think I'm going to talk about another issue quickly that's a hot topic right now, and that is the idea of there being a labor shortage. And that's the case in many situations where, we see it in the healthcare industry, often in the trucking industry, education, that right now there is a shortage of workers and there are a lot of jobs available. And that might be true. Certainly that has become more of a trend also in the remote work situation, right? So we talked about remote work earlier, and the fact that there are still many employers who permit people to work remotely. Doesn't matter where you work from. You could work for a company in Toronto and live in Barrie or in Collingwood or even somewhere further. That is very common these days, and it's creating a lot of jobs. So when there are a lot of jobs, what happens in terms of severance is your employer might say, well, you'll be able to find a job very quickly, so you're not entitled to as much severance. Sometimes an employer argues that. And sometimes that is true, but often it's not true, because even though there might be a lot of jobs in your industry, the job still has to be comparable. In cases it isn't. You could be someone who worked in healthcare and you were earning $50 an hour, and then you're terminated from that position. And now your employer says, well, you could easily go find another job in healthcare. And you could find a job in healthcare, but it may not be a job that's comparable to the one you were performing before. And in terms of severance pay, your employer could only argue potentially that your severance pay is reduced if there are many jobs available to you that are very similar to the one that you were doing before. So similar in terms of pay, similar in terms of duties, similar in terms of work location. All of these things are very important. And so while there might be jobs in many industries, that's true, there is a labor shortage, not in all industries, but in many. Again, in terms of severance pay and how that works when you're terminated, it has to be that the job is a comparable job. You don't have a duty to accept a job that is very different from the job that you were doing before. And again, I see this all the time because I help people every day who are terminated from their positions, who are claiming severance pay. And in that situation, their employer might say, but you can go find another job very quickly. And I often argue, well, that's not necessarily true. It depends on the industry. It depends on if those other jobs available in the industry are paying the same, are the same rank in the organization. It depends where it's located. So you don't have to just accept any job when you're terminated. Again, this is something that we can help you with. So please contact us, and you can get more of your questions answered live at our next live session, which you see on the screen, is Wednesday, February 22nd. So tomorrow with Lior Samfiru at 1 p.m. If you have any questions that I did not get to today, I'll be back again, absolutely. But join us at our next Q&A session tomorrow, and we can get your questions answered. Thank you very much. It was great to be with you again, and I look forward to seeing you soon. Take care.